Insider dealing under the Securities and Futures Ordinance of Hong Kong. The Securities and Futures Ordinance contains civil and criminal market misconduct offences under Parts 13 and 14 of the SFO. There are 6 types of market misconduct covered: insider dealing, false trading, price rigging, disclosure of information about prohibited transactions, disclosure of false and misleading information inducing transactions, and stock market manipulation. What I'm going to talk about now is a summary of the laws on insider dealing. Civil cases of market misconduct are dealt with by the Market Misconduct Tribunal, while criminal cases go before the courts. So what is insider dealing? In broad terms, insider dealing typically occurs where a person connected with a Hong Kong listed company, such as a director or staff member, has privileged information which could impact the company's share price when it becomes publicly known, and trades or procures someone else to trade the company's securities or derivatives so as to make a profit or avoid a loss before the information becomes publicly available. Or a person obtains information from another person they know to be connected with a listed company and trades or procures another person to trade in the company's securities or derivatives so as to make a profit or avoid a loss before the information becomes publicly available. The SFO definition of insider dealing covers 7 circumstances. Firstly, a person with inside information deals in shares of a corporation with which he or she is connected. Insider dealing happens when a person connected with a listed company has inside information which he or she knows is inside information in relation to that company and deals in the company's listed securities or their derivatives or in those of a related company, or counsels or procures another person to deal in such listed securities or derivatives, knowing or having reasonable cause to believe that the other person will deal in them. Secondly, a takeover offer where the bidder deals in shares of a target. The term takeover offer is defined in Schedule 1 to the SFO. Insider dealing occurs when a person who is contemplating or has contemplated making a takeover offer for a listed company and knows that the information that the offer is contemplated or is no longer contemplated is inside information. Deals in the company's listed securities or their derivatives or in those of a related corporation otherwise than for the purpose of the takeover, or counsels or procures another person to deal in such listed securities or derivatives otherwise than for the purpose of the takeover. This provision is designed to stop, for instance, a director of a company which is about to launch a takeover bid from telling his friends to buy shares in the intended target in order to make a profit when the price of those shares inevitably rises. The provision is also designed to catch, say, a director of the bidder who sells short in the target when he knows, but the public doesn't, that the bidder is not going to increase its offer price at the end of the initial offer period, but will instead let the offer lapse. It doesn't stop the director of the bidder from buying shares in the target, or in fact counselling or procuring others to do so in a dawn raid, where the sole purpose of such purchases is to facilitate the takeover itself. Thirdly, a person connected with a company leaks inside information about that company. Insider dealing will also take place when a person connected with a listed company has information which he or she knows is inside information in relation to the company and discloses the information directly or indirectly to another person, knowing or having reasonable cause to believe that the other person will use the information to deal or counsel or procure another person to deal in the company's listed securities or their derivatives or in those of a related company. This offence is designed to cover the person who deliberately leaks confidential information with a view to someone, whether it be the person to whom he's leaked the information or some other person, using that information to make a favourable deal trading the securities on the Hong Kong Stock Exchange. Fourthly, a bidder leaks takeover information. Insider dealing also happens when a person who's contemplating or has contemplated making a takeover offer for a listed company and knows that the information that the offer is contemplated or no longer contemplated is inside information, discloses the information directly or indirectly to another person, knowing or having reasonable cause to believe that the other person will use the information to deal or to counsel or procure another person to deal in the company's listed securities or their derivatives or in those of a related company. This section applies where a person who's contemplating or has contemplated making a takeover offer for another company leaks to another person information to the effect that he or she is contemplating such an offer or is no longer contemplating such an offer, with a view to that other person using the information to deal in the target securities or to counsel or procure someone else to deal in them. Fifthly, a recipient of inside information from a person connected with a company deals in shares of that company. It's also insider dealing when a person has information which he or she knows is inside information in relation to a listed company, which he or she received directly or indirectly from a person who he or she knows is connected with the company and who he or she knows or has reasonable cause to believe held the information as a result of being so connected, deals in the company's listed securities or their derivatives or in those of a related company, or counsels or procures another person to deal in such securities or derivatives. This covers the recipient of the leaked information who uses it either by dealing himself or by counseling or procuring someone else to deal. The person who actually leaks the information would be caught by sections 271C and 291(3). In the MMT case of China Huiyuan juice, which I'll discuss in more detail later, the MMT ruled that the fact that the identity of the connected person is unknown is not fatal to an insider dealing charge under this subsection. Next, a recipient of inside information about a takeover deals in shares of the target. Insider dealing also happens when a person has received, directly or indirectly, from a person who he knows or has reasonable cause to believe is contemplating or no longer contemplating making a takeover offer for the listed company, information to the effect which he knows is inside information in relation to the company, and deals in the company's listed securities or their derivatives or in those of a related company, or counsels or procures another person to deal in such listed securities or derivatives. This provision catches the recipient of the leaked information who uses it either by dealing himself or herself or by counseling or procuring someone else to deal. The person who actually leaks the information would be caught by sections 271D and 2914. Next, a person with inside information seeks to facilitate a dealing on an overseas market. Insider dealing also happens when a person who knowingly has inside information in relation to a listed company in any of the circumstances I've already gone through, and counsels or procures another person to deal in the company's listed securities or their derivatives or in those of a related corporation, knowing or having reasonable cause to believe that the other person will deal in such listed securities or derivatives outside Hong Kong on an overseas stock market, or discloses the inside information to another person, knowing or having reasonable cause to believe that he or she or some other person will use the inside information to deal or counsel or procure another person to deal in the corporation's listed securities or their derivatives, or in those of a related corporation outside Hong Kong on an overseas stock market. Insider dealing in foreign listed securities. Where insider dealing involves securities that are listed on foreign exchanges, the court may rely on the offence of using fraudulent or deceptive devices in transactions in securities, futures, contracts, or leveraged forex trading under Section 300 of the SFO, rather than Section 270 or Section 291. This was demonstrated by the landmark decision in the Court of Final Appeal case SFC against Young, Bick, Fung, and others. Two solicitors, Betty and Eric, were found guilty of illegally profiting from inside information. The case involved two solicitors who worked at separate law firms at the time and thus owed fiduciary duties to their principals, the relevant law firms, including various duties of loyalty and confidentiality. They were Also subject to restrictions on trading securities. The solicitors were in a relationship and cohabited between 2003 and 2006 and remained friends after the relationship ended in 2006. Two other defendants in the case were sisters of the lawyers. One of the solicitors, Betty, had been seconded by her employer to a Hong Kong bank to assist on the Hong Kong bank's takeover of Sin Chu International Bank Company Limited, which was listed on the Taiwan Stock Exchange. She'd been reminded and had acknowledged that she was an insider and had access to highly confidential and inside sensitive information. Discussions took place between the two banks between August and September 2006. Information about the tender offer and the offer price of 24 Taiwan dollars and 50 cents per share constituted confidential price-sensitive information about Sin Chu's shares before the public announcement of the tender offer on 29 September 2006. Betty was aware of the confidential price-sensitive information on the 14th of September 2006. 9 days before the tender offer, on 20th of September 2006, a new securities account was opened with Taifuk Securities by the third defendant, which allowed her to trade in Taiwanese shares. Between 21st and 29th of September 2006, the four defendants put together substantial sums of money and injected them into the Taifuk account. Between the 22nd and 29th of September, the third defendant acquired 1,576,000 shares in Sin Chu for the defendants at an average price of 16 Taiwan dollars and 99 cents. The two solicitor defendants went to considerable lengths to raise funds, including drawing overdrafts and liquidating a considerable portion of their investment portfolios. One solicitor borrowed 300,000 from her sister, while the other borrowed 430,000 from his sister. The two solicitor defendants went to considerable lengths to raise funds, including drawing overdrafts and liquidating a considerable portion of their investment portfolios. One solicitor borrowed 300,000 Hong Kong dollars from her sister, while the other borrowed 430,000 from his sister. The third defendant, who obtained the money by breaking a fixed deposit due to mature in 2 weeks, resulting in the forfeiture of interest of over 1,000 Hong Kong dollars. On the 29th of September 2006, when the tender offer was announced, the offer price was 44% above the average price of the defendant's acquisitions. The third defendant accepted the tender offer for all the Sin Chu shares in the Taifuk account and distributed the profit of around 2.69 million Hong Kong dollars in proportion to their contributions. The court also considered a second transaction in which the roles of the two solicitor defendants were reversed. The second defendant was the tipper and the first defendant was the tippee. The court relied on Section 300 of the SFO as opposed to the SFO's insider dealing provisions because of the extraterritorial feature of the case. The insider dealing regime applies to securities listed on the Hong Kong Stock Exchange. Since the securities involved in the case were listed in Taiwan, the defendant's conduct was outside the scope of the Hong Kong insider dealing regime. Section 300 of the SFO prohibits fraudulent or deceptive schemes in transactions involving securities. Section 300 prohibits a person from employing any device, scheme, or artifice with intent to defraud or deceive, or engaging in any act, practice, or course of business which is fraudulent or deceptive, or would operate as a fraud or deception, directly or indirectly, in a transaction involving securities, futures, contracts, or leveraged forex trading. In order to establish the Section 300 defense, the conduct must be fraudulent or deceptive and relate to a transaction involving securities. The court had no difficulty in applying Section 300 based on the facts of the case. It held that Betty's decision and conduct in misusing confidential material price-sensitive information and knowingly breaching dealing restrictions which applied to her as a person working on the deal amounted to a scheme or act of deception. The definition of transaction in Section 300, subsection 3 of the SFO includes an offer and invitation, however expressed. There's no requirement for the transaction to have been completed. Since the offer to buy the securities was made in Hong Kong, Section 300 applied. The fact that the securities were traded outside Hong Kong was irrelevant. The court also accepted that the third defendant's acceptance of the tender offer in Hong Kong would also have brought the case within the scope of Section 300. The court held that for the purposes of Section 300, the fraudulent and/or deceptive conduct is consummated when the information is deployed to sell or purchase securities, and not from the moment the fraudster obtains the confidential information. The Court of Final Appeal held that Section 300 of the SFO could be applied in respect of securities outside of Hong Kong, provided substantial activities constituting the crime occurred within Hong Kong. The court found that substantial activities of the case did occur in Hong Kong. So what are the definitions that are being used when we look at insider dealing under the Securities and Futures Ordinance? Well, it's extremely important to consider each of these because they go to the root of the ingredients of the offences created within this insider dealing regime. So firstly, securities. These are broadly defined in Part 1 of Schedule 1 to the SFO and include shares, stocks, debentures, loan stocks, funds, bonds, or notes of or issued by, or which it's reasonably foreseeable will be issued by a body, whether incorporated or unincorporated, or a government or municipal government authority. Rights, options, or interests, whether described as units or otherwise, or in respect of any of these. Certificates of interest or participation in, temporary or interim certificates for, receipts for, or warrants to subscribe for or purchase any of the instruments I've just mentioned. Interest in a collective investment scheme, any interest, rights, or property commonly known as securities, whether in the form of an instrument or not, and structured products not falling within the descriptions I've just given, where a structured product is an instrument under which some or all of the return or amount due, or both the return and the amount due, or the method of settlement is determined by reference to one or more of, firstly, changes in the price, value, or level, or a range within the price, value, or level of any type or combination of types of securities, commodity, index, property, interest rate, currency, exchange rate, or futures contract. Secondly, changes in the price, value, or level, or a range within the price, value, or level of any basket of more than one type, or any combination of types of securities, commodity, index, property, interest rate, currency, exchange rate, or futures contract, or the occurrence or non-occurrence of any specified event or events, excluding an event or events relating only to the issuer or guarantor of the instrument, or to both the issuer and the guarantor. A regulated investment agreement, any interests, rights, or property prescribed or of a class or description prescribed by notice under Section 392 of the SFO as being regarded as structured products. So what's the definition of listed securities? The SFO's insider dealing offences apply only to securities listed on the Hong Kong Stock Exchange at the time of the dealing in question. The definition of listed securities includes issued unlisted securities, provided that at the time of the insider dealing, it's reasonably foreseeable that they will be listed, and they are subsequently in fact listed, and issued securities, provided that at the time of the insider dealing, it's reasonably foreseeable that they will be issued and listed, and they are subsequently in fact issued and listed. This is intended to catch grey market dealings prior to a secondary issue of securities. As insider dealing can only occur in relation to a listed corporation, insider dealing in an IPO grey market is not covered. The market manipulation provisions may, however, apply to such trading to the extent that it affects post-listing prices and trading. Securities are also treated as listed, notwithstanding that dealings in them may have been suspended. The definition of corporation includes the large number of companies which are listed in Hong Kong but incorporated abroad. A person connected with a corporation, an insider, is someone who is on the inside track, who has access to information about a company by reason of his relationship with it. Sections 247 and 287 define an individual as connected with a corporation if he's a director or employee of that corporation or a related corporation. Directors include shadow directors, that is, persons in accordance with whose instructions the corporation's directors are accustomed or obliged to act. He's a substantial shareholder, that is, has an interest in 5% or more, of the issued voting share capital in the corporation or a related corporation, his position may reasonably be expected to give him access to inside information concerning the corporation by reason of a professional or business relationship existing between himself or his employer or a corporation of which he's a director or a firm of which he's a partner, and that corporation, a related corporation, or an officer or substantial shareholder in either corporation, or his being a director, employee, or partner of a substantial shareholder of the corporation or a related corporation, or he has access to inside information by virtue of being connected within the meanings I've just mentioned with another corporation where that information relates to a transaction, actual or contemplated, involving both corporations or involving one of them and the listed securities of the other or their derivatives, or to the fact that such transaction is no longer contemplated, or he was connected with the corporation within the meanings of the matters I've just discussed at any time within 6 months preceding any relevant dealing. A corporation is connected with another corporation if any of its directors or employees are so connected. Under sections 248 and 288, any public officer or member or employee of certain bodies who in his capacity as such obtains inside information about a corporation will be deemed to be connected with that corporation. Related corporations. 2 or more corporations will be related corporations of each other if one of them is the holding company of the other, the subsidiary of the other, or a subsidiary of the holding company of the other. Corporations are also related where the same individual controls the composition of the board of directors of one or more corporations, controls more than half of the voting power at general meetings of one or more of the corporations, or holds more than half of the issued share capital, excluding any part which carries no right to participate beyond a specified amount on a distribution of either profits or capital of one or more corporations. Each of the corporations I've referred to and their respective subsidiaries are regarded as related corporations of each other. What's the definition of inside information? Section 2451 of the SFO defines inside information in relation to a corporation as specific information about the corporation, a shareholder or officer of the corporation, or the listed securities of the corporation or their derivatives, which is not generally known to the persons who are accustomed or would be likely to deal in the listed securities of the corporation, but which would, if it were generally known to them, be likely to materially affect the price of the listed securities. Inside information may therefore include information about changes in a corporation's shareholders or officers and about rights attaching to listed securities and derivatives over those securities. The definition of inside information which applies to the insider dealing offences is the same as the definition which applies to Hong Kong listed corporations' obligation to publicly announce inside information under Part 14A of the SFO. Guidance on what information constitutes inside information is set out in the SFC's Guidelines on disclosure of inside information. Inside information must be specific. Information will be specific if it's capable of being identified, defined, and unequivocally expressed. In the case of Firstone International Holdings, Chinese Estates Holdings, Chinny Alliance, and Gilbert Holdings, it was determined that information will be sufficiently specific if, quote, it carries with it such particulars as to a transaction, event, or matter, or proposed transaction, event, or matter, so as to allow that transaction, event, or matter to be identified and its nature to be coherently described and understood. Information doesn't need to be precise in order to be specific. According to the SFC guidelines, it's not necessary that all particulars or details of a transaction, event, or matter are precisely known. Information may still be specific, even if it has a vague quality, and may be broad, which allows room, even substantial room, for further particulars. For example, information that a company is having a financial crisis would be regarded as specific, as would contemplating a forthcoming share placing, even if the details are not known. However, specific information is to be contrasted with mere rumors, vague hopes and worries, and with unsubstantiated conjecture. Inside information that is known only to corporate insiders and is not generally known to the market, defined as persons who are accustomed or would be likely to deal in the company's listed securities. The fact that there are rumors, media speculation, or market expectation as to an event or set of circumstances relating to a corporation doesn't mean that the information is generally known to the market. The SFC has noted that a clear distinction between the market having actual knowledge of a fact, which has been properly disclosed by the corporation, and speculation of what might have occurred with respect to a corporation which remains to be proved. Information in the media, analyst research reports, or electronic subscription databases. Information relating to a corporation that appears in the media, analyst research reports, or electronic subscription databases may consist of published historical financial information, market commentary, speculation, rumor, or leaked information. This information cannot be assumed to be information that's generally known to the market, even where media reports are widely circulated. In determining whether information appearing in the media and research reports is generally known, corporations must consider not only how widely the information is disseminated, but also the accuracy and completeness of the information, and whether the market can rely on the information. In particular, corporations should consider whether the sources contain all the information the corporation would need to disclose as inside information under Section 307(b)(3) of the SFO, so that there are no material omissions which make the disclosure false or misleading. The market will realize that the information in these sources reflects the information known to the corporation, and the information will be regarded as speculation or opinion of persons outside the corporation. If the information known to the market is incomplete, or there are material omissions or doubts as to its bona fides, the information cannot be considered to be generally known, and the corporation to have made full disclosure. Information that's likely to have a material effect on the price of the listed securities. Section 2451 requires that inside information must be information which would, if it were generally known to the wider investing public, to be likely to materially affect the price of the listed securities. That's to say, the information must be price sensitive. It's not sufficient that the information would simply affect the price of the securities. The effect must be material. Information that would be likely to cause a mere fluctuation or a slight change in price would not be sufficient. There must be the likelihood of change of significant degree in any given circumstances that amount to a material change. Information that is likely materially to affect the price of a corporation's securities is information which may well materially affect the price. That is, it's more likely than less likely that the price will be affected materially. The standard by which materiality is judged is whether the information on the particular share would influence persons who would be likely to deal in the share in deciding whether or not to buy or sell it. The test of whether the information is likely to materially affect the price is necessarily a hypothetical one, since it has to be applied at the time the information becomes available. Obviously, there are no fixed thresholds of price movements or quantitative criteria that can determine the materiality of a price movement. Volatility of blue chip shares is typically less than that of small, less liquid stocks, and blue chip securities usually move within ranges narrower than those of small stocks. Hence, smaller percentage movements may be material for large company stocks. While the actual magnitude of the share price movement, once the information becomes publicly known, indicates the extent of probable change the information might have caused, this is by no means conclusive. It's possible that the actual price change once the information is released is moderate due to the mixed impact of the information released and other extraneous factors. Further, a material price movement may have been preempted by the fact that the share price has already declined substantially in the period leading up to the release of the information. The ruling of the Market Misconduct Tribunal case of Warderly International Holdings shows that the fact that a connected person dealt in shares of a listed company while in possession of inside information doesn't always constitute insider dealing, as it's fact-specific. I'll talk about that case in more detail a bit later. Dealing in securities. Under Section 249 of the SFO, a person deals whether he acts as principal or agent. Agreeing to deal and buying or selling the right to deal will also be dealings under the SFO. Sections 271 and 292 of the SFO set out defences to insider dealing, where a person can establish that they fall within one of the following categories. The dealing, counselling or procuring was made for the sole purpose of acquiring qualifying shares as a director or intending director of a corporation, in good faith in performance of an underwriting agreement for the listed securities or derivatives in question, or in good faith as a liquidator, receiver, or trustee in bankruptcy. There is a Chinese wall defense. A corporation, for example, an investment bank or a sponsor's firm, will have a defense if it can demonstrate that there were effective arrangements in place, i.e. a Chinese wall, to ring-fence any inside information in the possession of any of its directors and employees, and each person who took the decision for the corporation to deal, counsel, or procure a dealing in the listed securities or derivatives in question did not have the inside information at that time and had not received advice from those in possession of such information. It's also a defense if the purpose for which a person dealt in or counselled or procured another to deal in the listed securities or their derivatives or disclosed information did not include the purpose of securing or increasing a profit or avoiding or reducing a loss, whether for themselves or another, by using the inside information. The use of the innocent purpose defense, as it's called, was clarified in October 2018 when the Court of Final Appeal delivered its decision in the case of SFC against Huiyuan, which I'll talk about later. It's a defense if a person dealt or counselled or procured another to deal in a company's listed securities or their derivatives as agent. He didn't select or advise on the selection of such listed securities or derivatives, and he didn't know that the person for whom he acted was connected with that corporation or had the inside information. It's also a defense if the dealing occurred off-market in Hong Kong and the person dealing in listed securities or their derivatives and the other party entered into the dealing directly with each other, and at the time of the dealing, the other party knew or ought reasonably to have known of the inside information, or where a person counselled or procured another person to deal in listed securities or their derivatives, he counselled or procured the other party to enter into the dealing directly with him, and at that time, the other party knew or ought reasonably to have known of the inside information. It's a defense where a person dealt in listed securities or their derivatives, but did not counsel or procure the other party to deal, and at the time of the dealing, the other party knew or ought reasonably to have known that he was a person connected with the corporation. This defense operates on the assumption that people who transact with someone they know or should know as a company insider should be on notice that the other party may be insider dealing, and so make adequate inquiries with the insider before dealing with them and maybe negotiate terms as to the disclosure of inside information. A person will have a defense if they counselled or procured another to deal in listed securities or their derivatives and establishes that the other person didn't counsel or procure the other party to the dealing to deal in the listed securities or derivatives, and at the time he counselled or procured the other person to deal, the other party to the dealing knew or ought reasonably to have known that the other person was a person connected with the corporation. This gives a defense to a person who counsels or procures a person to deal in the same circumstances as a defense is available to a person who deals in the way I've just described. It is really a logical extension of that defense and would, for example, protect an investment bank which introduced a prospective purchaser to a substantial shareholder of a listed corporation who the bank thought might want to tender to divest their shareholding and advise the shareholder on the sale. A defense is available to a person who dealt or counselled or procured another to deal in a company's listed securities or their derivatives where the person acted in connection with any dealing which was under consideration or was the subject of negotiation or in the course of a series of such dealings and with a view to facilitating the accomplishment of the dealing or the series of dealings. And the inside information was market information arising directly out of his or her involvement in the dealing or the series of dealings. Market information is defined to include facts such as that there has or is to be, or that there has not been or is not to be a dealing in listed securities or their derivatives, or that any such dealing is under consideration or negotiation, the quantity and price or price range of the listed securities and the derivatives, and the identity of the persons involved. This gives a defense to a person who trades with knowledge of his own trading intentions or activities, and also to those who simply execute or facilitate a trade on his behalf. This defense caters for the situation in which a person whose trading activities might be price-sensitive information, for example, a substantial shareholder and therefore a connected person, increases his stake in a listed company. Without such an explicit defense, a person dealing with insider information about their own trading activities is technically insider dealing. Dealing subject to the rules of a recognized clearinghouse will have a defense where the deal was entered into by the clearinghouse with a clearing participant for the purposes of the clearing and settlement of a market transaction. Sections 272 and 293 provide a further defense where a trustee or personal representative dealt in or counseled or procured a dealing in listed securities or their derivatives on advice obtained in good faith from an appropriate person who did not appear to him to be a person who would have been involved in insider dealing if he himself had dealt in the listed securities or their derivatives. Sections 273 and 294 provide a defense where a person dealt in listed securities or their derivatives in the exercise of a right to subscribe for or otherwise acquire such securities or their derivatives, which was granted to him or was derived from securities held by him at a time when he was not aware of any inside information. The innocent purpose defense provided by Section 2713 of the SFO was clarified on the 12th of October 2018 when the CFA ruled in a 4-1 decision for the SFC in SFC against Yu Hong Ying. The respondents, Yu Hong Ying and Ms. Wong Nam, held 6 million shares and 10 million shares in Asia Telemedia, respectively. Asia Telemedia owed a debt of around 58 million Hong Kong dollars to Good Pine Limited. In April 2007, Good Pine served a statutory demand on ATML and stated that it would issue a winding up petition against ATML if the debt was not repaid within 21 days. While this was known to Mr. Yu and Ms. Wong, it has not been announced to the public. At the same time, shares in ATML experienced a price surge. Mr. Yu took advantage of the surge by selling all of his 6 million ATML shares in May 2007 and obtained a net profit of around 5 million Hong Kong dollars. Ms. Wong sold her 10 million ATML shares between February and June 2007 and also made a net profit of around 5 million Hong Kong dollars. The SFC alleged in proceedings before the Market Misconduct Tribunal that the respondents' knowledge of Good Pine's statutory demand to ATML constituted inside information and that they engaged in insider dealing when they relied on that information to dispose of their ATML shares at a profit. Mr. Yu and Ms. Wong relied on the innocent purpose defense by claiming that the reason for their disposals was the speculative surge in ATML's share price at the time and not their knowledge of the inside information, that is, Good Pine's issue of a statutory demand and threat to wind up ATML. They argued that ATML's financial situation would be dealt with behind closed doors eventually and wouldn't influence the market. The MMT and later the Court of Appeal accepted that defense. However, that defense was rejected in the Court of Final Appeal's 4-1 decision for the SFC. Whether Mr. Yu and Ms. Wong could rely on the defense turned on what constitutes use of the inside information. The CFA reasoned that using inside information means turning the possession of inside information into action. Mere withholding or non-disclosure of inside information is insufficient to show use of the inside information. The inside information had to be exploited for financial advantage. The respondents knew that the price of the ATML shares was artificially high because of the inside information they possessed, and they disposed of the shares to profit from that knowledge. The CFA's ruling seems to suggest that officers of a listed corporation are considered to be using inside information and cannot rely on the innocent purpose defense if they possess inside information which is not publicly known when they deal in the corporation's securities. The respondent's belief as to what might happen in the future, i.e. that ATML's financial situation would be dealt with behind closed doors, was considered irrelevant. The defense does not apply as long as the inside information played a role in the decision-making, regardless of how big or small a role the inside information had in the decision-making process. What mattered was whether the elements of insider dealing were satisfied and whether the defense was applicable when the transaction took place. The implications of the judgment are that officers of listed companies who possess inside information should avoid dealing in the company's shares until the inside information has been publicly announced. So what are the consequences of insider dealing? The SFO creates dual civil and criminal insider dealing regimes. The Market Misconduct Tribunal conducts civil proceedings and, where appropriate, imposes civil sanctions against those it determines to be wrongdoers. The MMT is an independent body chaired by a judge or former judge who sits with 2 members and a presenting officer appointed by the Secretary of Justice when conducting proceedings. It's inquisitorial and is entitled to direct that the SFC carry out further investigations and report their findings to the MMT. Under the SFO, the presenting officer is a lawyer whose role is to present evidence to the MMT. He should be more like a prosecuting counsel rather than a counsel assisting the tribunal, and he should be independent. There are detailed provisions in the SFO governing the composition of and procedures to be followed by the MMT. If it appears to the SFC that market misconduct has or may have taken place, it can institute proceedings before the MMT under Section 252 of the SFO. Proceedings are instituted by the SFC, giving the MMT notice specifying the matters prescribed by Schedule 9 to the SFO. The purpose of the MMT proceedings is to determine whether any market misconduct has taken place, the identity of persons who have engaged in market misconduct, and the amount of any profit gained or loss avoided as a result of the market misconduct. The MMT may identify a person as having engaged in market misconduct if he's perpetrated any market misconduct. The market misconduct was perpetrated by a corporation of which he's an officer with his consent or connivance, or another person engaged in market misconduct, and he assisted or connived with that person in the perpetration of the market misconduct, knowing that such conduct constituted or might constitute market misconduct. The MMT makes its findings on the civil standard of proof. It therefore needs to be satisfied that a person has engaged in market misconduct on the balance of probabilities, rather than beyond reasonable doubt, which is the criminal standard of proof. The MMT has powers to receive any evidence, whether or not the evidence would be admissible in civil or criminal proceedings. It also has wide powers to compel the giving of evidence and to prevent the publication of information about the evidence it receives. Significantly, a person is not excused from complying with the requirement of the MMT to give evidence on the grounds that to do so might incriminate them, Section 2534, and such compelled self-incriminatory evidence may be considered by the MMT. In the SFC against Cheng Chak Nok, the SFC had appealed against the MMT's decision that Mr. Cheng had not engaged in insider dealing in shares of China Gas Holdings. The Court of Appeal allowed the appeal and examined certain principles. Mr. Cheng was the Executive Director, Chief Financial Officer, and Company Secretary of ENN Energy Holdings, which in 2011 considered acquiring China Gas. Sinopec agreed to form a consortium with ENN to finance the acquisition. Mr. Cheng had responsibility for negotiating the financial proposal for ENN. He obtained information regarding the consortium formed to finance the acquisition, the timing of the announcement of the general offer, and the offer price. The SFC considered that insider dealing had been committed by Mr. Cheng when he used a third party's securities account to purchase China Gas shares immediately prior to its suspension of share trading before the announcement. He obtained a profit of approximately 3 million Hong Kong dollars when he later sold the shares. However, on the available evidence, the MMT decided that it wasn't satisfied on a balance of probabilities that Mr. Cheng had dealt in China Gas shares at the material times. Consequently, insider dealing couldn't be proved. The SFC appealed against that decision. The principles set out by the Court of Appeal. The Court of Appeal noted that the nature of the MMT's inquiry on market misconduct is civil and inquisitorial. This means that the judge has an examining or inquiring role in investigating the facts, rather than the impartial role of the judge in an accusatorial system. The function of the MMT is to inquire into the question of insider dealing, not to decide between competing positions or claims. MMT proceedings are inquisitorial. As the nature of inquiry by the MMT is civil, the standard of proof is on a balance of probabilities. Case law establishes that the standard of proof will be proportional to the seriousness of the allegations. That is, the more serious the allegation, the more compelling the evidence required. The concept of burden of proof is only relevant in adversarial proceedings. In inquisitorial proceedings, no party has the burden of proof. The SFC specified 4 grounds of appeal. The MMT had erred in law, misdirecting itself that the inquiry was adversarial in nature, misdirecting itself that the burden of proof applied and rested with the SFC, and failing to exercise its investigative powers under the SFO. The MMT had applied a criminal standard of proof, which required the SFC to prove the case beyond reasonable doubt, and evidential principles applicable to criminal proceedings in evaluating the evidence. The MMT erred in concluding that it could not be satisfied that Mr. Cheng had engaged in insider dealing on a balance of probabilities, and the MMT failed to exercise its investigative powers under the SFO before concluding the inquiry. The Court of Appeal found that the MMT had not properly evaluated the available evidence and was wrong in applying the criminal standard. The MMT accepted that Mr. Cheng's evidence was confusing and suspicious, but instead insisted on the SFC providing more compelling evidence to prove the case. The MMT thus erred in requiring the SFC to prove the case on the basis of the criminal standard of proof. The Court of Appeal also found that the MMT had incorrectly imposed the burden of proof on the SFC. The Court of Appeal's view was that no burden of proof need to be imposed on an inquisitorial inquiry. The SFO requires the SFC to present evidence to the MMT to enable the MMT to come to a decision. The Court of Appeal thus provided clarification that in market misconduct proceedings before the MMT, the SFC is only required to present evidence and information to the MMT which would investigate the facts to reach a decision on a balance of probabilities. At the end of any proceedings, the MMT may, under Section 2571 of the SFO, impose certain sanctions on a person found to have committed market misconduct. Firstly, a disqualification order, that a person shall not, without the leave of the court of first instance, be or continue to be a director, liquidator, or receiver or manager of the property or business of a listed corporation or any other specified corporation, or in any way, whether directly or indirectly, be concerned or take part in the management of a listed corporation or other specified corporation for up to 5 years. A cold shoulder order, that a person shall not, without the leave of the court of first instance in Hong Kong, directly or indirectly deal in any securities, futures contract, or leveraged foreign exchange contract, or any interest in any of them, or a collective investment scheme for up to 5 years. A cease and desist order, that the person must not again engage in any specified form of market misconduct. That the person pay to the government an amount up to the amount of any profit gained or loss avoided as a result of the market misconduct. A government costs order, that the person pay to the government its costs and expenses in relation to the proceedings and any investigation. That the person pay the SFC's costs and expenses in relation to any investigation, and that any body which may take disciplinary action against the person or as one of its members be recommended to take such action against them. A disgorgement order may, at the discretion of the MMT, be made subject to compound interest from the date of the occurrence of the market misconduct in question. The SFC also has the ability to fine regulated persons. When making an order, the MMT can take into account any previous convictions in Hong Kong, any previous findings of market misconduct by the MMT, and any previous findings of insider dealing under the predecessor ordinance. Failure to comply with a disqualification, cold shoulder, or cease and desist order is a criminal offence under subsections 25710 and 25810, punishable by a maximum fine of 1 million Hong Kong dollars and/or up to 2 years imprisonment. In addition, sections 2532 and 2546 prescribe a penalty of a maximum fine of 1 million Hong Kong dollars and a maximum of 2 years imprisonment for failure to comply with various requirements of the MMT or disrupting its proceedings. The conduct referred to in those sections and in sections 25710 and 25810 is also liable to be punished as contempt under section 261. Any person who is dissatisfied with the finding or determination of the MMT can appeal to the Court of Appeal, but only in respect of a point of law or with the leave of the Court of Appeal on a question of fact. Under the SFO, a party who is not satisfied with certain decisions by the SFC may appeal to the Securities and Futures Appeal Tribunal. Recent MMT and SFAT decisions have reiterated that SFC disciplinary proceedings are civil in nature for the purpose of the Hong Kong Bill of Rights, and the civil standard of proof in section 2187 of the SFO, allowing for flexibility in respect of the seriousness of the issue, the sliding scale of proof, should be used in any SFC disciplinary proceedings and SFAT proceedings, except for charges of contempt. It's possible for the civil threshold to approach or even be identical to the criminal standard if the potential penalty can lead to a loss of liberty. However, generally, the standard of proof in disciplinary proceedings of offences that are not generally applicable to the public, but only to a limited group of individuals, such as licensed persons, would not be criminal. The China Huiyuan Juice Group case. In this case, Ms. Sun Min was prosecuted for buying around 8.6 million shares of China Huiyuan Juice, a PRC fruit drinks producer listed on the main board of the Hong Kong Stock Exchange, on 6 different occasions through 4 different companies ahead of its announcement that it would be acquired by Coca-Cola. Ms. Sun was the owner of a shipping business, and she made a profit in excess of 55 million Hong Kong dollars when she sold all her shares in the company within 48 hours after the public announcement of the Coca-Cola takeover. Ms. Sun had close connections with the management of the company, but there was no direct evidence proving that she had received inside information on the Coca-Cola takeover. She denied having any inside information or knowledge of the takeover. The SFC's case against her centered around the circumstantial evidence and inferences from handwritten notes on the Coca-Cola takeover found in Ms. Sun's secretary's diary, which were taken in a meeting between Ms. Sun, her husband, her secretary, and the COO of Ms. Sun's shipping company. The SFC was unable to identify from which connected person the inside information came. The secretary was unable to recall how the information was collected, nor whether it was passed to her by her employer. The MMT held that if the identity of the connected person who passed on the insider information could not be ascertained, the MMT would decide, based on all available evidence, whether a compelling inference could be drawn that the inside information must have been from an unidentified connected person and that Ms. Sun must have known of that fact. The information did not constitute mere rumour and was fact-specific. Some of the handwritten notes in the diary concerned PRC antitrust law. The MMT considered that an ordinary investor would not have considered PRC antitrust law issues unless they knew of the potential Coca-Cola takeover. On that basis, the MMT inferred that the information came from an insider, even though the insider's identity could not be ascertained. The MMT also considered that the inside information in the diary must have come from Ms. Sun, or she must have known of the information, absent any reasonable reason that would have been passed on in the normal course of events. The MMT therefore rejected the secretary's evidence that she was unsure whether she'd passed on the information to Ms. Sun. I'll now talk about the 2016 case of Warderly International Holdings. Warderly International Holdings was a company previously listed on the main board of the Hong Kong Stock Exchange and engaged in the production of electronic goods in China. In mid-2006, Warderly encountered cash flow problems due to a surge in raw materials prices and the settlement of a large profit tax claim from the Hong Kong IRD. From July 2006, it defaulted in repaying bank loans, and banks tightened their credit lines to Warderly, and suppliers stopped providing raw materials. There were also several labor strikes in China factories between 2006 and April 2007 due to unpaid or delayed wages. Certain events and loans occurred between November 2006 and May 2007. On the 23rd of August 2006, Warderly's annual report for the year ended 30th of April 2006 showed a dramatic fall in net profits of 58 million Hong Kong dollars in the previous year to a mere 398,000 Hong Kong dollars. On the 17th of November 2006, Warderly's subsidiary, Sharp Venture Holdings Limited, borrowed from Mr. Liu a loan of 2 million Hong Kong dollars at an interest rate of 5% per month, repayable after 1 month, and interest at 1.5% per month thereafter if the loan remained outstanding. On the 11th of December 2006, Mr. Liu lent a further 1.2 million Hong Kong dollars to Sharp Venture with the loan terms to enable it to pay its workers over Chinese New Year. On the 28th of December 2006, Mr. Liu, via his company Vision Eagle, lent another 6 million Hong Kong dollars to another Warderly subsidiary, Housley Industries, with the loan terms. A letter of authorization was also executed by Mr. Yuan, the chairman and majority shareholder of Warderly, pledging all his 231.8 million Warderly shares to Mr. Liu as security. And on the 23rd of January 2007, Warderly announced its interim results for the 6 months ended 31st October 2006. This showed net profit had dropped to just over 2 million Hong Kong dollars from over 20 million Hong Kong dollars for the same period in 2005, and the bank balance had reduced from 116 million Hong Kong dollars to just over 27 million Hong Kong dollars. On the 28th of January 2007, Warderly failed to repay the loan plus interest that was due to Mr. Liu. Between February 2007 and 4th of April 2007, Mr. Liu, a potential investor who was initially interested in acquiring Mr. Young's shareholding in Warderly and to restructure the Warderly Group, lent a total sum of 10 million Hong Kong dollars to Housley at a monthly interest rate of 3% per month. Mr. Young pledged 50 million Warderly shares at 20 cents per share to Mr. Liu. Mr. Liu further committed himself, subject to due diligence, to take up the additional 12.8 million Hong Kong dollars debt owed by Warderly to Mr. Liu. On the 12th of March 2007, Warderly announced a potential acquisition of an oil project in China. And on the 14th of May 2007, trading in Warderly shares was suspended with a closing price of 48 cents. Mr. Lo Hang Feng was a partner of a Hong Kong law firm and the legal advisor and company secretary of Warderly at the material time. He bought 1,597,500 Warderly shares in late 2003 and early 2004 at prices between 1.14 Hong Kong dollars and 1.20 Hong Kong dollars per share. It was alleged that before the public was made aware of Warderly's financial position, he sold all his Warderly shares on 3 occasions on the 28th, 29th, and 30th March 2007 for prices between 51 and 53 cents per share. It was also alleged that the 50 million Warderly shares pledged by Mr. Young and held by Mr. Liu via his 3 nominees were sold on his instructions on 3rd, 4th, and 30th of April 2007 and on the 2nd of May 2007 for prices between 39 and 48 cents. The SFC argued that the following specific events were relevant information, which is now renamed inside information. The tightening of bank facilities since July 2006 and the subsequent events such as overdue loans, rescheduled payments, demand letters and writs issued by banks and lenders. the $2 million loan from Mr. Liu on the 17th of November 2006 at an interest rate of 5% a month. Further loans from Mr. Liu totaling $7.2 million at an interest rate of 5% on the 11th and 28th of December 2006. Warderly's failure to repay the loan and interest due to Mr. Liu when they had become due on the 28th of January 2007, and the $10 million loan from Mr. Liu in February 2007 that carried an interest rate of 3% per month and was secured by 50 million Warderly shares. The SFC alleged that Mr. Liu and Mr. Liu engaged in insider dealing as they were in possession of relevant information concerning Warderly's poor financials, which was not publicly known, and avoided losses by selling their Warderly shares. The MMT heard evidence as to whether the 5 specified events were relevant information. The MMT held that information regarding Warderly's poor financials were already known to the public, as its dire financial state was already disclosed in its annual report of August 2006 and the interim report for the 6 months ended 31st October 2006. The MMT considered that the financial reports showed that Warderly was in serious financial trouble, and even the most unsophisticated investor would understand. Further, the news of the issuance of writs for unpaid loans was already in the public domain. Therefore, by the time the price per share hit its lowest level of 0.214 Hong Kong dollars, just over 2 cents, after the publication of the poor finances and news of ongoing litigation in relation to unpaid loans, the increasing difficulty with securing funding, the various loans taken out, and the loan defaults were trivial in nature. The public already knew of the poor financial position of Warderly. This was supported by the fact that from examining historical stock prices of Warderly, the publication of the news of the issue of writs for unrepaid loans had no adverse effect on the stock price. By early February 2007, Warderly shares were trading as if it were a shell company for backdoor listing. Warderly was already being evaluated for its potential to be reinvested with a different core business than electronic goods manufacturing, which were of little or no consequence by then. The MMT heard from experts that in cases of potential backdoor listing, the share price often rises dramatically, along with market increases in the trading volume and increased volatility due to rumor and press comment. The MMT noted that from February 2007, the price of Warderly stocks spiked and increased trading volume compared to the month prior thereto. Such activity maintained until the stock was suspended on the 14th of May 2007. There was also the announcement of the possible injection of an oil processing company into the Warderly Group and increased press comments in March and April 2007. All these supported the view that Warderly was trading as a shell company ripe for backdoor listing. As such, by the end of March 2007, the 5 specified events could not be shown to be relevant information which, if publicly known, would materially affect the share price. So Mr. Liu and Mr. Liu were not held to have engaged in insider dealing. Trading in Warderly shares was suspended on the 14th of May 2007. On the 16th of December 2013, after a backdoor listing, Warderly resumed trading under a different name and engaged in property, building, investment, and healthcare businesses. The Warderly case shows that a connected person dealing in listed stocks while in possession of price-sensitive information doesn't always constitute insider dealing. Whether insider dealing has taken place or not is fact-specific. All forms of market misconduct, including insider dealing, are liable to prosecution as a criminal offence under Part 14 of the SFO. The maximum criminal sanctions under the SFO are a maximum of 10 years in prison and fines of up to 10 million Hong Kong dollars. In addition, the court can make disqualification, cold shoulder, and disciplinary referral orders. Failure to comply with a disqualification or cold shoulder order is an offence liable to a maximum fine of 1 million Hong Kong dollars and up to 2 years in prison. A person will not be subject to the double jeopardy of both civil proceedings under Part 13 and criminal proceedings under Part 14 for the same conduct. The SFO provides that a person who has been subject to criminal proceedings under Part 14 may not be subject to MMT proceedings if those proceedings are still pending or if no further criminal prosecution could be brought against that person, again, under Part 14 in respect of the same conduct and vice versa. The decision as whether to take criminal or civil proceedings in relation to suspected market misconduct is made by the Secretary of Justice. The SFC may also institute summary criminal proceedings before a magistrate for less serious market misconduct offences, although the Secretary of Justice is able to intervene in the SFC's conduct of any such proceedings. The decision whether to take criminal or civil proceedings is made in accordance with the Department of Justice's prosecution policy, which provides true criteria for the institution of criminal proceedings, that there is sufficient evidence for a criminal prosecution, and that a criminal prosecution is in the public interest. If these tests are not met, suspected market misconduct will be dealt with through civil proceedings before the MMT. The SFO provides a private right of civil action against any person who's committed market misconduct or any offence under Part 14 in favour of anyone who's suffered a pecuniary loss as a result, unless it is fair, just and reasonable that the perpetrator should not be liable. A person will be taken to have committed market misconduct if he's perpetrated any market misconduct, a corporation of which he's an officer perpetrated the market misconduct with his consent or connivance, or any other person committed market misconduct and he assisted or connived with that person in the perpetration of the market misconduct, knowing that such conduct constitutes or might constitute market misconduct. It's not necessary for there to have been a finding of market misconduct by the MMT or a criminal conviction under Part 14 before bringing civil proceedings. Findings of the MMT are, however, admissible in the civil proceedings as prima facie evidence that the market misconduct took place or that a person engaged in market misconduct. Further, a criminal conviction constitutes conclusive evidence that the person committed the offence. The courts are able to impose injunctions in addition to or in substitution for damages. Sections 280 and 304 of the SFO provide that a transaction is not void or voidable by reason only that it constitutes market misconduct. Section 279 of the SFO imposes a duty on all officers of a corporation to take reasonable measures to ensure that proper safeguards exist to prevent the corporation from acting in a way which would result in the corporation perpetrating any market misconduct. The definition of an officer of a corporation includes a director, including a shadow director and any person occupying the position of a director, manager or secretary of, or any other persons involved in the management of the corporation. The last category, that's any other person involved in management, could in principle cover supervisors and anyone else with management responsibilities. Under Section 258, where a corporation has been identified as having been engaged in market misconduct, and the market misconduct is directly or indirectly attributable to a breach by any person as an officer of the corporation of the duty imposed on him under Section 279, the MMT may make one or more of the orders detailed in respect of that person, even if that person has not been identified as having engaged in market misconduct themselves. As I've already mentioned, the SFO clearly provides that anyone who suffers pecuniary loss as a result of market misconduct has a right of civil action to seek compensation. As I noted, an officer of a corporation which perpetrates market misconduct is taken to have committed market misconduct themselves if the corporation perpetrated the misconduct with their consent or connivance. Under Section 390 of the SFO, where it's proved that an offence committed under Part 14 was aided, abetted, counselled, procured, or induced by, or committed with the consent or connivance of, or attributable to the recklessness of any officer of the corporation or any person purporting to act in any such capacity, that person, as well as the corporation, is guilty of the offence and liable to be punished accordingly. Under Part 14 of the SFO, any regulated person who's guilty of misconduct or who, in the opinion of the SFC, is not a fit and proper person to be or to remain the same type of regulated person is subject to a widened range of disciplinary procedures. Misconduct is defined to include any contravention of the SFO or of the terms of any license issued or registration made under it. The SFC can revoke or suspend a person's license in respect of all or any part of the regulated activities for which they're licensed. In addition, or alternatively, the SFC can impose a fine not exceeding the greater of 10 million Hong Kong dollars or 3 times the amount of the profit gained or loss avoided by the regulated person as a result of their misconduct, or such other conduct which led to the SFC's opinion that they are not fit and proper. The SFC can also impose prohibition orders preventing an offending person from, among other things, applying to be registered or licensed under the SFO. Approvals granted to responsible officers may also be suspended or revoked. Persons covered by these provisions include corporations licensed under the SFO, their responsible officers, and persons involved in their management. Significantly, authorized financial institutions which must be registered with the SFC to conduct regulated activities, for example, securities dealing, asset management, etc., their executive officers, persons involved in the management of their regulated business, and individuals named in their register as carrying out a regulated activity are also subject to the SFC's disciplinary regime. Section 213 of the SFO enables the Court of First Instance on the application of the SFC to grant orders to prevent or remedy breaches of the SFO and other relevant ordinances. Section 213 of the SFO also covers aiding, abetting, or assisting, counselling, or procuring another person to commit a breach of the SFO, inducing by threats, promises, or otherwise another person to commit a breach of the SFO, directly or indirectly being knowingly involved in or a party to a breach of the SFO, or attempting or conspiring with others to commit a breach of the SFO. The available remedies include, but are not limited to, injunctions and orders requiring the person to take steps to restore the parties to a transaction to the position they were in before the transaction, or restraining or prohibiting a person from acquiring, disposing of, or dealing in any property. The CFI has to satisfy itself that it is desirable to make one or more of the orders and that the order will not unfairly prejudice any person. The decision of the CFA in Securities and Futures Commission against Tiger Asia Management and others confirmed the power of the CFI to make final orders sought by the SFC under Section 213 of the SFO on the basis of insider dealing or other market misconduct, without there having been a prior finding of such market misconduct by either the MMT or a criminal court. Tiger Asia was a New York-based asset management company with no physical presence in Hong Kong. Tiger Asia and 2 of its senior officers were found to have breached the insider dealing and market manipulation provisions of the SFO in dealing in shares of Bank of China and China Construction Bank in December 2008 and January 2009, and manipulated the price of CCB shares in January 2009. With respect to the BOC shares, Tiger Asia was invited to take part in 2 placings of BOC shares in December 2008 and January 2009, respectively. It was provided with confidential and price-sensitive details of both placements. Upon receiving the inside information, Tiger Asia agreed not to deal in BOC shares. It then sold short 104 million and 256 million BOC shares before both placements and made profits of around 9 million and a loss of around 10 million, respectively. With respect to the CCB shares, Tiger Asia was invited to take part in the proposed placing by a placing agent who told Tiger Asia about confidential and price-sensitive information on the size and the discount range of the proposed placement. Tiger Asia made a profit of around $32 million by short-selling 93 million CCB shares before news of the placing became public. Tiger Asia then covered its short sales with the placement shares bought at a discount to the prevailing market rate. Tiger Asia also manipulated the CCB share price during the closing auction session. The court ordered Tiger Asia and the 2 senior officers to pay around 45 million Hong Kong dollars to investors affected by their insider dealing. Section 213 of the SFO is remedial in nature and is concerned with handling the adverse consequences of actual or potential market misconduct. Proceedings commenced under Section 213 of the SFO are standalone proceedings and are intended to provide remedies to protect interests of those involved in the impugned transactions. Section 213 of the SFO serves as another avenue through which the SFC protects investors' interests. It's also clear from the Hong Kong SAR and Du Jun that the SFC can pursue both criminal proceedings for insider dealing or other market misconduct offences and an order under Section 213 of the SFO. Mr. Du Jun, a former Morgan Stanley managing director of the Fixed Income Department, was involved in ongoing projects with CITIC Resources and learnt that CRH intended to acquire an oil field in China. On the basis of that inside information, he bought a total of 26.7 million shares of CRH between February and April 2007. The total purchase cost was around 87 million Hong Kong dollars. The share price spiked after the public announcement of the proposed acquisition of the oil field in China. He made a profit of around 33 million and a loss of around 31 million when he sold all his CRH shares on 2 occasions. Mr. Du Jun was convicted of insider dealing, for which he was sentenced to 6 years in prison and fined 1.7 million Hong Kong dollars. In separate Section 213 proceedings in December 2013, the court granted a restoration order against Mr. Du Jun, ordering him to pay 23.9 million Hong Kong dollars to 237 investors affected by the insider dealing. The amount ordered to be paid was restored to counterparties to the insider dealing transactions in an attempt to restore them to their pre-transaction positions through payment of the difference between the shares on the date of the transaction, taking into account the inside information Mr. Du Jun had, and the actual transaction price. Another insider dealing case was the case of SFC against Mr. Chan Pak Ho Pablo, and it provides guidance for sentencing in insider dealing cases. Mr. Chan was a representative of the controlling shareholder of Universe International Holdings and was convicted of insider dealing in Universe shares by the Eastern Magistrates Court. He was involved in Goldwyn Management Limited's proposed acquisition of Universe from the controlling shareholder between March and June 2008. He gained price-sensitive information between May and June 2008 from his involvement in the negotiation, and he subsequently bought 3.88 million Universe shares. On June 19, 2008, it was announced that Universe's controlling shareholder was in negotiations with a third party for the disposal of its entire shareholding in Universe, and trading in Universe shares was suspended. The share price increased by around 40% when trading resumed, and Mr. Chan made a profit of 120,000 Hong Kong dollars when he disposed of all of his Universe shares. Mr. Chan was initially sentenced to 240 hours of community service and was ordered to pay the SFC's investigation costs of 44,478 Hong Kong dollars by the Eastern Magistrates Court. This meant that he could retain the profits he made from insider dealing. On the SFC's application to the Eastern Magistrates Court for a sentence review, the magistrate sentenced Mr. Chan to 4 months in prison and ordered him to pay a fine of 120,000 Hong Kong dollars, representing the profit he made from insider dealing. The Court of First Instance, on hearing Mr. Chan's appeal, indicated that the starting point of a custodial sentence for insider dealing should be 6 months imprisonment. The court upheld the community service order and the cost order due to the court's interpretation of Section 1049 of the Magistrates Ordinance, which states that the magistrates lack jurisdiction to grant the application for review of a sentence once Mr. Chan had lodged a notice of appeal against his conviction. However, the Court of Final Appeal reversed this interpretation and held that a pending appeal against one part of a magistrate's decision doesn't preclude a review by that magistrate of another part of their decision in the same case. So, the High Court's sentencing was set aside, and the magistrate's sentencing on review, being 4 months in prison and 120,000 Hong Kong dollar fine, was restored. Taking into account the fact that Mr. Chan had already completed the community service order by that time, 3 months imprisonment, a fine of 120,000 Hong Kong dollars, and the costs order were imposed instead. The Honourable Mr. Justice Ribeiro stated that the appropriate sentencing for insider dealing cases is a custodial sentence, and a fine to disgorge all the profits made from insider dealing. In the Hong Kong SAR against Du Jun, the Court of Appeal acknowledged that the differing circumstances of each insider dealing case means that sentencing will vary between cases. However, the Court of Appeal endorsed the following 8 sentencing considerations from the case of the Crown against McCoy. The nature of the defendant's employment or retainer or involvement in the arrangements which enabled the person to participate in the insider dealing of which they're guilty. The circumstances in which they came into possession of confidential information and the use made of it. Whether the person behaved recklessly or acted deliberately and almost inevitably, therefore, dishonestly. The level of planning and sophistication involved in the activity, as well as the period of trading and the number of individual trades. Whether the person acted alone or with others, and if so, their relative culpability. The amount of anticipated or intended financial benefit, or, as sometimes happens, loss avoided, as well as the actual benefit or loss avoided. Although the absence of any identified victim is not normally a matter giving rise to mitigation, the impact, if any, where proved on any individual victim, and the impact of the offence on overall public confidence in the integrity of the market. Because of its impact on public confidence, it's likely that an offence committed jointly by more than one person trusted with confidential information will be more damaging to public confidence than an offence committed in isolation by one person acting on their own. In the case of the Hong Kong Aircraft Engineering Company, Mr. Albert Lam Kwong Yu, former Civil Aviation Department Director and former non-executive director of the then main board-listed Hong Kong Aircraft Engineering Company, HAECO, was convicted of insider dealing of HAECO shares by the Eastern Magistrates Court and was sentenced to 5 months imprisonment, suspended for 2 years. He was also fined $50,000 and ordered to pay half of the SFC's investigation costs, totaling over 107,000 Hong Kong dollars. Mr. Lam obtained price-sensitive information as a non-executive director of HAECO regarding Swire Pacific's acquisition of 15% of HAECO's stocks from Cathay Pacific. He bought 4,000 HAECO shares on 4th of June 2010, minutes after he was informed of the price-sensitive information and that an urgent board meeting would be held on the same day about the acquisition. Mr. Lam made a profit of 79,000 Hong Kong dollars from the trade. The court rejected Mr. Lam's case that he was intoxicated by alcohol when he made the online trade. To complete the trade, he was required to access his email and online banking accounts, move between web pages, insert details of the trade, and transfer money to the security account in which he had insufficient funds to complete the trade. These tasks required him to be conscious and alert. The case of China CMB Group Company Limited. Mr. Aoyang Siu Pang, former Group Finance Director of GEM-listed China's CBM Group Company, was sentenced to 4 months in prison and was fined $120,000 by the Eastern Magistrates Court for insider dealing in China's CMB shares. Around the 27th of March 2012, he learnt of 2 pieces of insider information relating to China's CBM while he was involved in auditing the company's financials for the year ended 31st December 2011. He became aware that China's CMB suffered an unaudited loss of around RMB 52 million in 2011 and was at risk of trading in its shares being suspended because the outstanding audit issues could not be resolved in time for the 2011 annual results to be published on time. On the 28th of March 2012, on the basis of such inside information, Mr. Aoyang counselled or procured his father to sell 500,000 China CBM shares beneficially owned by Mr. Aoyang, and on the following day he sold 600,000 China CMB shares himself. On the 30th of March 2012, trading in China's CMB shares was suspended. When trading resumed on the 4th of October 2012, the share price dropped 20% compared to the last traded closing price before the trading suspension. Mr. Aoyang's insider dealing resulted in him avoiding a notional loss of 174,000 Hong Kong dollars. Recent developments in the area of insider dealing. While there's certainly a role of big data, recently the SFC has focused on adopting new technology to detect possible cases of insider dealing. sometimes referred to as big data, reg tech, or soup tech. These tools allow regulators to monitor trading patterns in large amounts of data and identify suspicious trading activity that suggests that insider dealing has occurred. The US SEC's Analysis and Detection Center of the Market Abuse Unit has been in operation since 2010 and is responsible for analyzing trade patterns and data to detect insider dealing in the US. In early 2017, the SEC entered into a supervisory cooperation arrangement with the SFC to facilitate information sharing between the regulators on regulated entities such as investment advisors, broker-dealers, and securities exchanges operating in the US and in Hong Kong. The increased use of new technology, combined with information sharing between regulators, could lead to a more collaborative global effort to tackle insider dealing. What is a Chinese wall? Section 4.3 of the Corporate Finance Advisor Code of Conduct provides that where a corporate finance advisor, which is licensed or registered under the SFO, is part of a professional firm or group of companies undertaking other activities, for example, auditing, banking, research, stockbroking, and fund management, the CFA should ensure that there is an effective system of functional barriers, known as Chinese walls, to prevent the flow of information that may be confidential or price sensitive between the corporate finance activities and the other business activities. It specifies that the system should include physical separation between and different staff employed for the various business activities. It's for each CFA firm to decide what procedures and controls it should have to maintain an effective system of functional barriers in accordance with Section 4.3 of the Corporate Finance Advisor Code of Conduct. To prevent market abuse, many financial markets participants use Chinese walls. According to the UK Financial Conduct Authority, a Chinese wall is an arrangement that requires information held by a person in the course of carrying on one part of its business to be withheld from or not to be used for persons with or for whom it acts in the course of carrying on another part of its business. In a bank, a Chinese wall separates the M&A advisory division, which will often learn of inside information from its work for corporate clients on acquisitions, and its trading division, which is restricted from trading if it knows such information. Chinese walls not only prohibit market participants from acting, but are also supposed to protect them. If the information is held behind a Chinese wall, this provides evidence that the organization didn't deal on the basis of inside information. For example, a broker-dealer can continue to engage in trading activities without fear of being guilty of insider dealing. So Chinese walls are used to prevent insider dealing and conflicts of interest by preventing the flow of non-public information. Chinese walls usually include physical separation of departments in different wings or floors of a building, maintenance of separate accounting systems, records, support staff, and restrictions on sensitive documents. The SFC published an FAQ to clarify the meaning of and assist in compliance with the Chinese walls requirement in 2013. And I'll go through some of what this covers. The importance of Chinese walls, in addition to the duty not to disclose confidential and or price-sensitive information to clients, CFA firms and their staff also have a broader duty to act fairly in the best interests of their clients, avoid conflicts of interest situations, and ensure the fair treatment of their clients. The rationale behind Chinese walls, therefore, is that any price-sensitive and or confidential information which a CFA has through advising on corporate finance, mergers and acquisitions should not be disclosed inappropriately or otherwise used by the firm or its staff, whether for its own benefit or for the benefit of other clients. Any disclosure of such information should be restricted to people who need to know. For example, in order to enable the firm to provide its services to the relevant corporate finance client. The existence of Chinese walls is essential to reduce the risk of confidential or price-sensitive information being misused or wrongly disclosed, which also risks contravention of the laws on insider dealing by preventing the spread of information between different departments of CFA firms. The managing director, the board of directors, the chief executive officer, or other senior operating management personnel of a CFA are responsible for ensuring compliance with the Chinese walls requirement. Senior operating management personnel cover those in a position of authority over a CFA's business decisions. The senior management should ensure that effective Chinese walls are in place and that careful consideration is given to where Chinese walls are placed within the organization and which staff are grouped together. It's for each CFA to determine when it has confidential or price-sensitive information which has to be protected. Generally, the SFC would expect non-public corporate finance information about a client to be confidential to that client. So the importance of physical separation. Section 4.3 requires that the effective system of functional barriers should include physical separation between and different staff employed for the various business activities. Whereas CFA carries on different businesses, physical separation helps reduce the risk of accidental leakage and disclosure by confining information to a limited number of persons with a limited physical area. Although physical separation is a necessary element in an effective system, it's not of itself enough to constitute effective Chinese walls. The SFC also accepts that it's not necessary for corporate finance staff to be permanently physically separated from all other staff on the private side, which normally refers to groups of staff who deal directly with clients and have access to inside information, which is not available to the public. However, corporate finance staff must always be physically separated from non-private side staff, for example, stockbroking staff and proprietary traders. Other measures to maintain Chinese walls. In addition to physical separation, the senior management of CFA firms should look at the totality of their information handling procedures and controls to assess whether they have an effective system. In determining the nature and extent of measures a CFA firm should adopt, it should consider the functions and roles of the staff on the private side that the firm plans to group together, whether the features of specific transactions require the information to be held confidentially within a specific team, whether facilities for temporary separation are necessary for particular deals or teams within the Chinese walls, and whether physical separation should be a permanent arrangement between particular business units. Permanent physical separation between a firm's corporate finance business and its proprietary traders is always necessary. In addition to physical separation, the senior management should also consider certain areas that can form part of the Chinese walls. Implementing a compliance culture and attitude, that's how to promote a compliance culture that values protection of client information, for example, through training, disciplinary action against staff in breach of policies, management, example, etc. Conflicts management, controls and procedures. Conflicts management arrangements can help mitigate risks of information, misuse or disclosure. Conflict checks should be undertaken as soon as possible for new transactions or clients, and in any event, before any pitch for any specific mandate, substantive discussions or presentation to an appropriate business approval committee. It may also be necessary to obtain informed consents from relevant clients when conducting a conflict check. Ways of handling or storing information. For example, firms should consider implementing clear desk policies for paper documents, and meetings where corporate finance information is to be discussed should be held in private. The use of code names for projects and deals should also be considered. Physical controls in office settings, for examples, include ensuring that visitors are accompanied at all times, holding client meetings only in client meeting rooms, and where necessary, holding internal discussions on matters that should not be discussed in shared office space in Chinese box rooms, to which access is limited to specific deal team members. IT infrastructure. Examples of tech controls that may be implemented include a printing system, which only allows employees to print materials sent from their computer by swiping a personal access card on the printer's control device, and setting up segregated computer drives for individual deal teams for each transaction with restricted access and password-protected filing systems. Emails containing confidential information should be required to be encrypted. Support functions. All staff, including those in support functions, should be subject to firms' information handling procedures and controls. Firms which rely on physical separation of their corporate finance businesses from their other activity should also consider whether and how that separation is reflected in the relevant support functions. Insider lists and above-the-wall staff. Firms should maintain and regularly review lists of their employees with access to inside information relating directly or indirectly to corporate finance information, whether on a regular or occasional basis. The SFC recognizes that some senior management staff and staff responsible for compliance will have access to corporate finance information, but without themselves being part of a firm's corporate finance business. Appropriate controls should be implemented to ensure that these staff comply with the firm's and their own information handling obligations. Training. Firms are required to train staff on the relevant legal and regulatory requirements and the firm's procedures and controls to meet those requirements. Refresher training should be implemented from time to time. Wall crossings. Corporate finance information may sometimes be legitimately disclosed by persons within a firm's corporate finance business unit to staff on the non-private side of a Chinese wall, and sometimes even to other clients, for example, to conduct market soundings in a placing, wall crossing, or bringing someone over the wall. However, such disclosures must be subject to proper controls and must not be made if such staff or client has expressly or impliedly refused to be brought across the wall. In particular, this must be done on a need-to-know basis. For example, because the recipient's views on a transaction are needed, and the recipients must be subject to a duty of confidentiality such that they can't use or disclose the information for their own or others' benefit until the information becomes public or otherwise ceases to be price sensitive. Firms should keep proper records of such wall crossings. The FAQ acts as a reminder that this guidance is not directed at what firms must do to comply with the terms of the inside of the Chinese wall defense to insider dealing. Also, corporate finance is not the only business in which client confidential information or price-sensitive information arises. Therefore, all firms and staff should protect client confidentiality and prevent misuse of confidential information in all circumstances. There are certain disadvantages of Chinese walls. A Chinese wall doesn't entirely stop the flow of inside information and prevent insider trading, nor does it always reduce conflicts of interest. Chinese walls are more successful in preventing the accidental flow of inside information than they are in preventing purposeful misconduct and conspiracies to share inside information. Since a Chinese wall is not successful in preventing an investment banker from intentionally disclosing inside information to retail traders, these deliberate disclosures of inside information will continue to occur. A client's right to be fully informed about all the facts may be jeopardized because of the lack of flow of information within an organization. For example, a Chinese wall may prevent a large multi-service firm from fulfilling its duty of undivided loyalty to customers. According to this fiduciary duty, a broker-dealer must disclose to its customers all material facts within its knowledge that in any way affect the transaction. The existence of a Chinese wall may prevent retail traders from using information obtained from investment bankers to satisfy this duty of the firm's retail traders. Chinese walls may exert additional financial burdens on companies to set up effective management of price-sensitive information. Chinese walls may prevent companies from opportunities for collective thinking and other synergies of combining and integrating various departments. Given that Chinese walls are not perfect and have disadvantages, a company may consider the use of a watch list and restricted list to reinforce the Chinese wall. The use of restricted lists and watch lists are commonly used in Hong Kong. The SEC has proposed that a firm use a restricted list in addition to a Chinese wall. A restricted list is a list of securities maintained by a firm in which proprietary, employee, and certain solicited customer transactions are restricted or prohibited. An issuer or security may be placed on the restricted list in order to reinforce a firm's information barrier, to comply with trading practices and other rules, to avoid the potential appearance of impropriety, or to meet other compliance or regulatory objectives. When an issuer appears on the restricted list, certain sales, trading, and research activities involving that issuer's securities or other financial instruments may be restricted. Restricted activities include proprietary trading, including market making, solicitation of client orders, the recommendation of the issuer's securities and transactions for any employee, associated person, or related account with respect to the related securities or financial instruments. The restricted list is usually maintained by a firm's compliance department or by an institutional control room. However, an obvious problem with the use of a restricted list is that the firm's placing of a security on the restricted list may be equivalent to revealing the adverse information itself, particularly if the firm previously recommended the security. If the firm has an outstanding buy recommendation on the security, it will place the security on a restricted list if it obtains adverse information. This will rescind the recommendation, but also keep the information from customers. However, the placement of the security on the restricted list signals that the firm has obtained negative information, because otherwise it could continue to recommend the security. The SEC has attempted to address this problem by stating that the firm should place a security on the restricted list as soon as it enters into any relationship likely to result in the receipt of inside information. Obviously, this is not a very precise rule and may result in inconsistent application and uncertainty by broker-dealers regarding their potential liability. A restricted list is merely an addition to a Chinese wall, so all the disadvantages of Chinese walls would still be in existence. The use of watch lists. Broker-dealers typically use watch lists in addition to Chinese walls and restricted lists. Implicit in the use of watch lists and restricted lists is the assumption that Chinese walls are insufficient to prevent the flow of inside information. A watch list is a list of securities whose trading is monitored by the firm's compliance department, but there are no formal trading restrictions placed on them. The watch list is the most important element of Chinese wall review procedures. This list enables the firm to determine if the Chinese wall is effectively preventing the flow and misuse of material non-public information. A watch list is only successful in detecting insider trading after it's already occurred, so it doesn't serve to improve the effectiveness of a Chinese wall. Restricted lists, in contrast, attempt to prevent insider trading in the beginning. It's been argued that these attempts at improving Chinese walls ultimately have proved ineffective and simply perpetuate their disadvantages. Firms that conduct both investment banking and research or arbitrage activities must maintain some combination of restricted and watch lists and should conduct regular reviews of trading in securities appearing on the lists. The self-regulatory organizations set out specific minimum documentation standards concerning these lists, including records of the firm's methods for conducting reviews of employee and proprietary trading, the firm's procedures for determining whether trading restrictions will be implemented, and the firm's explanations of why, when, and how a security is placed on or deleted from a restricted or watch list. Further, the firm must adequately document how it monitors employee trading outside the firm of securities on the restricted or watch lists. The SFC against Young Big Fung case was a case involving the issue of a Chinese wall. Two solicitors, Eric and Betty, and others had contravened the SFO by insider dealing in the shares of Asia's satellite telecommunications holdings and had engaged in fraud and deception in transactions involving Hsinchu International Bank Company shares. The defendant argued that the existence of a Chinese wall in Linklaters, the law firm, should militate against the possibility of accidental leaks of confidential information to people outside the team. The SFC argued that the court should have regard to the realities of a legal office and highlighted the fragilities of Linklaters' Chinese wall. There was also evidence from Amy, Eric's secretary, which revealed that fragilities in Linklaters' system existed. For example, she didn't lock her filing cabinets as no keys were provided. In relation to Section 2913, that's where a person connected with a corporation leaks inside information about that corporation to apply, it must be proved that Eric was a person connected with AsiaSat. In the factual circumstances of that case, the SFC had to prove, pursuant to Section 2871C1 of the SFO that Eric occupied a position which may reasonably be expected to give him access to relevant information in relation to AsiaSat by reason of a professional or business relationship existing between Linklaters and CITIC Group, which is AsiaSat's major shareholder. Section 2871C1 of the SFO says that for the purposes of Division 2, a person shall be regarded as connected with a corporation if, being an individual, he occupies a position which may reasonably be expected to give him access to relevant information in relation to the corporation by reason of a professional or business relationship existing between himself or his employer or a corporation of which he is a director or a firm of which he is a partner, and the corporation, a related corporation of the corporation, or an officer or substantial shareholder of either corporation. The test of connected person is an objective one, namely what other people may reasonably expect of that person by virtue of their position. The limit that the definition places on the range of individuals who are connected persons can be summarized in this passage. I quote, "This objective test narrows the range of individuals within the definition of insider. It excludes individuals such as employees or other individuals in specified professional or business relationships who occupy positions that quite unexpectedly give them access to unpublished price-sensitive inside information. Hence, an individual's formal position prevails over the qualitative nature of the information," unquote. The defendant argued that although Eric was in the position of an employee within Linklaters, he was not part of the transaction team, as would reasonably be expected in any major law firm involved in corporate M&A work. Linklaters had a system in place to ensure that confidential information about any proposed deal that the firm was working on would be restricted only to those employees working on the deal. An employed solicitor who was not a member of the team working on the deal would not be in a position which may reasonably be expected to give him access to relevant information about that deal. It's clear from the evidence that Eric was not expected to have access to confidential information about the transaction in question. The court held that the Chinese wall in Linklaters didn't prevent Eric from gaining confidential, material price-sensitive information in relation to AsiaSat. However, it would not be a correct application of the objective test to hold that Eric was a connected person. The court cited a certain passage from a textbook. It may not always be a straightforward matter to determine whether an individual does occupy a position which may reasonably be expected to give him access to inside information about a company's securities. Take, for example, a market maker or investment manager in a securities house, in which there's also a corporate finance department. That securities house should ensure that a Chinese wall prevents inside information about corporate finance clients from leaving that department. If the corporate finance department is advising A Limited about a prospective bid for its shares, will this render X, an employee in the market-making department, connected with A Limited? The answer to that is probably no, since X, as a market maker in the securities house, does not occupy a position which may reasonably be expected to give him access to inside information about the securities of A Limited if Chinese wall arrangements have been adhered to. If the Chinese wall arrangements are breached so that X receives that information, this may be insufficient of itself to make him connected with A Limited, as that breach should not have occurred. In other words, the court held that Eric was not a connected person pursuant to Section 2913 of the SFO, notwithstanding that the court upheld the SFC's case based on Section 2915 of the SFO, i.e. Eric was a recipient of inside information from a person connected with a corporation dealing in shares of that corporation. The implication of this ruling is that by simply working in a professional firm like Linklaters, where Eric was a solicitor, but not in the team actually working on the confidential transaction in question, did not make Eric a connected person. This is because being in a different team of a firm that has Chinese wall arrangements in place would not bring Eric within Section 2871C1 as someone who occupied a position which may reasonably be expected to give him access to relevant information by reason of a professional or business relationship existing between Linklaters and the client. Another case was ASIC against Citigroup Global Markets Australia. In this case, the Federal Court of Australia gave its views on the adequacy of Chinese walls and took into account a company's compliance function in deciding whether there's a breach in the insider dealing provision under Australian law. The facts were that Citigroup Global Markets Australia conducted business through various business divisions, including investment banking. I'll call them private side employees, and equities trading, who I'll call public side employees. Private side employees were exposed to confidential market sensitive information, whereas public side employees were not to be exposed to such information. Citigroup had in place a Chinese wall to segregate the IB and the ET such that the flow of information between them was restricted. ET bought shares in Patrick Corporation Limited at a time when IB was representing Toll Holdings on a takeover bid for Patrick. ET bought the shares on the last trading day before Toll Holdings announced its bid for Patrick. IB took steps to mitigate its action after it became aware of ET's purchase. IB told ET to not buy any more Patrick shares. ET listened to this advice, but nevertheless sold 200,000 of Patrick's shares at a profit. Toll Holdings subsequently announced its takeover bid for Patrick the following date. When IB became aware of the purchase, steps were taken that resulted in ET being told to stop buying any more of Patrick's shares. ET didn't purchase any more shares, but half an hour before the close of trading, ET sold 200,000 of the shares that it had purchased that day at a profit. Toll subsequently announced its takeover bid for Patrick the following day. Well, whether Citigroup contravened insider trading provisions contained in Section 1043A of the Corporations Act 2001, ASIC argued that after IB informed ET about the potential conflict, ET made a supposition that Citigroup was acting for Toll in the proposed takeover of Patrick. ASIC argued that this supposition constituted information within the meaning of that term in Section 1042A of the Act. Thus, the disposal of the 200,000 shares should have constituted insider trading by Citigroup. This was the first insider trading claim, and argued that Citigroup's Chinese wall was not in place because it was likely that the senior IB personnel had knowledge of the takeover bid. That knowledge was attributable to Citigroup as a whole, and ET actually purchased Patrick's shares. That was the second insider trading claim. In relation to the first insider trading claim, this claim failed because the employee was not an officer. Under Section 1042G1A, the employee's knowledge was not attributable to Citigroup unless he was an officer of Citigroup, as defined by Section 9 of the Act. For this claim to succeed, the employee who executed the trade should not only possess the insider information, but have knowledge which is attributable to Citigroup. The court held that an officer for the purposes of the Act was someone with a senior management role, which this particular employee did not have. Also, Citigroup was acting for Toll in relation to the takeover of Patrick, and the employee had not made the supposition as alleged by ASIC. That is, he didn't have the inside information. The second insider trading claim also failed. Citigroup successfully raised the Chinese wall defense found in Section 1043F of the Act, that Citigroup convinced the court that it had compliance arrangements in place that could reasonably be expected to ensure that price-sensitive information held by IB was not communicated to ET or other public side employees. As required by the section, the decision to purchase the shares was made by a person other than the persons who held the information, and no information was communicated or advice given by IB with respect to the purchase. No appeal action was intended or lodged by ASIC. So what are the compliance implications? The Australian court noted that a Chinese wall does not have to be absolutely perfect. Rather, a company should ensure that there are reasonable steps to be taken in order to ensure the adequacy of a Chinese wall. The test is laid down in Section 1043F of the Act as an objective one. The court outlined certain relevant procedures that were required for effective Chinese walls: physical separation by departments, educational programs, procedures for dealing with crossing the wall, monitoring by compliance officers, and disciplinary sanctions. Citigroup's policies and training procedures with regard to Chinese walls. The court found that adequate procedures were in fact in place, referring to Citigroup's written policies and compliance procedures. The written policy required private side employees, that included IB, not to communicate material non-public information to persons on the public side, ET, without involving legal or compliance personnel to assess the materiality of the information, and when appropriate to implement wall crossing procedures. Citigroup's written policies were available to all staff. Regular training was provided, and the policies were clear that employees were to be alert to the possibility of conflicts and escalate any issues in relation to actual apparent or potential conflicts. Written policies and procedures of Citigroup were in place which set out the considerations that were to apply as to whether a public side employee should be brought over the Chinese wall. However, the court noted that adequate arrangements require more than a raft of written policies and procedures. They require a thorough understanding of the procedures by all employees and a willingness and ability to apply them to a host of possible conflicts. There was also a clear escalation policy in which IB was able to advise the appropriate persons of the potential conflict, including the Compliance Department, Citigroup's General Counsel, and CEO. Accordingly, Citigroup's in-house compliance division was able to properly advise IB and ET on what could or could not be disclosed to each other, and accordingly maintained the protection that the Chinese wall provided. The court found that such an escalation procedure supported the view that Citigroup had adequate Chinese walls in place. So this case demonstrated the importance of an effective Chinese wall system, which could help a company and its employees from breaching insider dealing provisions.